Hi everyone, good evening, and thanks to everyone for joining us this evening. I'm delighted to welcome you all to this interactive webinar where we have our leading education law expert, Steve Baylis, who will introduce himself in a moment too when we start the main content of the webinar shortly. In this evening's session, Steve will be talking to you all about the options available for children who have EHCPs or those who are otherwise vulnerable at this very challenging time we're living in, and also the provisions for SEND children generally at this time. My name's Emma Rush. I'm a partner here at Irwin Mitchell, and I'm hosting this evening's session for you. Firstly, I just want to say I know we're welcoming a number of families who've joined us through Caudwell Children, and we have many other families joining us too, which is fantastic. So a very warm welcome to you all from myself and from the team at Irwin Mitchell. I do a lot of work with Caudwell Children, and I'm so pleased that we've worked together to promote this webinar based on the feedback that we've had from families and from clients that we work with. Irwin Mitchell is a long-standing corporate supporter of Caudwell Children, and we're incredibly proud to support their valuable work over many years and during this special 20th anniversary year for them. I'm going to hand over to Steve in just a moment to get things underway, but just a few housekeeping points for you all first. There are no fire drills, you'll be pleased to know. If you have any questions during the webinar, please do just type them into the Q&A panel that you'll see in the centre bar on your screen. Thanks so much to everyone who's already submitted questions to us. Questions received during the session will be picked up towards the end of the session, and Steve and I will respond to as many as possible during the webinar. If we're unable to answer all of the questions, then we'll let you know how to get in touch with us about them at the end of the session. Finally, I just wanted to let you know that we're recording the webinar today, and a link to view the session again will be circulated in the email that we'll send to you over the next few days. So I'll hand over to Steve now.
Okay, so I just thought I'd set out from the start the legislation and the guidance and the relevant notices that we're relying upon at this moment in time, as we're talking really about what the duties are for local authorities in terms of meeting the needs of children with special educational needs and those who are vulnerable. The amendment regulations and the Secretary of State's notice are the differences in terms of the provision. They're the basis for how arrangements have differed, and so I think it's important that we know where those are and where to find them. What we're talking about in terms of the Secretary of State's notice is the second notice. This applies for the period from the 1st of June to the 30th of June, the Secretary of State previously having given a notice at the end of April for the month of May. As I'm sure everybody knows, from the 1st of June there was a return to school for nursery reception year 1 and year 6 students, and from Monday years 10 and 12. This of course being alongside the previous position where schools remained open for children with special educational needs, or actually children of critical workers and vulnerable children. So that included children with special educational needs, those with a child in need plan, a child protection plan, or a looked after child. Obviously, we've seen the recent news that the government is not intending to expand that position further into for the rest of this academic year, so this remains a position for the remainder of this year. I think it's important to understand that the government guidance recognises that younger children can't be expected to remain 2 metres apart, and social distancing as a result is difficult. I think, in practice, there's lots of challenges with this. The government guidance identifies different ways in which we can seek to minimise contact, keeping children and staff in small and consistent groups and away from each other. But I'm sure we all fully appreciate the practical challenges that brings. It's clear from the guidance that attendance of eligible children is strongly encouraged at this time, but of course being very mindful that people are extremely concerned about the risks to children, to themselves, to their relatives, to other people that they're coming into contact with. And so in line with that, the guidance identifies that parents will not be fined for non-attendance at this time. Obviously, there's complications that arise, particularly with children who aren't able to attend school because they're not in the years that are identified to return, and this is obviously in keeping with that approach, which is a reasonable approach, I would say, for the government to have taken. The safeguarding duties, though, do remain the same, and that's in accordance with the Keeping Children Safe in Education and the statutory guidance in there. So just because there are changes to the regime, there's no should be no watering down of the safeguarding duties in protection of the children at school. So we'll start with the amendment regulations, as I'll refer to them, and this is in relation to really the EHCP process, and that extends from the period of the 1st of May to the 25th of September. That, of course, is in line with the main Coronavirus Act, that's going to the 25th of September when the government must review it. So it can be extended, but this is the period of time that we're covering at the moment. Very important to remember that prior to that, all duties as they were in relation to children with special educational needs in accordance with the Children and Families Act and the Special Educational Needs and Disability Regulations 2014 continued to have effect. So the relevant period for which any local authority or health body may cite any amendments is looking at this confined period from the 1st of May onwards. Regulation 5 of the amendment regulations inserted a new regulation 2A into the 2014 regulations, effectively the coronavirus exception. So here we're looking at duties upon local authorities or health bodies, and they are to take specified actions and specified steps, which we'll go through shortly, rather than in the time period that was previously set in the Children and Families Act or the regulations, as soon as reasonably practicable. However, this applies where it's not reasonably practicable for a person to meet the requirement of the timescale for a reason relating to the instance or transmission of coronavirus. So this obviously is a potentially quite wide wording in terms of who will be caught within this and the types of situations that could be caught, but it does mean that any reason to not meet a time frame or comply with the duty as it was originally set out must be for the reasons relating to the incidence or transmission of coronavirus, and it's important that we keep that in mind as we think about actions that are taken. So paragraph 3 of that new regulation 2A lists the regulations which are amended, and I've set out the key ones on these slides. And we'll just go through them so that we're clear about which they are, because it doesn't apply to everything within the regulations, and it's important that we differentiate those that are included and those that are not. So the decision whether a local authority will carry out an EHC needs assessment ordinarily must be made within 6 weeks of the local authority receiving that request. That time frame, as with all, is as soon as reasonably practical. That will of course be dependent on each local authority's individual position, its staffing arrangements, how it's able to reach decisions, what actions it needs to take, and who is able to take those. But when we're thinking about within 6 weeks, that's our starting point, and then it's as soon as reasonably practical thereafter. So hopefully not a huge delay in that time frame, although I know in practice often that decisions on requests for assessment can be delayed, and so we need to make sure that the sort of delay, I guess, that is ordinarily occurs within the system is not extrapolated out here to become so long as to put children or young people at a disadvantage. So again, as soon as reasonably practical for a local authority to make its decision. If a local authority is requesting information from another body, the cooperation duty usually required the response to that request within 6 weeks. Again, that's as soon as reasonably practicable. I think that will depend on which other body is receiving that request, their staffing arrangements. Obviously, health bodies have had their resources quite stretched, understandably, at the moment, and have redeployed staff, so this could affect where they're able to meet that time frame, but they still should be able to identify who they have available and when. That means that within that, as soon as reasonably practicable part, they are able to provide the information for the local authority to inform its EHC needs assessment. Following the EHC needs assessment, the local authority would ordinarily, after 16 weeks from the date of receiving the request for assessment, so effectively 10 weeks from when the needs assessment was identified to be required, need to make a decision about whether to issue an EHCP. Again, this is one of the affected timeframes, but if the local authority has gathered the information, hopefully that doesn't cause a huge delay, because obviously they've identified there's a need for an EHCP and for the additional provision that a child or young person requires. So getting that sorted as soon as reasonably practicable is very important, and local authority needs to be thinking what steps it can take to help ensure that. And again, with sending the finalised EHCP out, the timescale is normally 20 weeks from the date of the request, so effectively 4 weeks from the date of the decision to secure an EHCP. Again, that time frame lengthened, but for our perspective, working for children and young people, we need to be making sure that as soon as reasonably practical is met, and we get that information and that finalised EHCP as soon as is possible after that 4-week period, because that's what is the legally enforceable provision within the EHCP. Likewise, excuse me, likewise, annual reviews of EHCPs, the ordinary position is within every 12 months. Here, that might not be possible for various reasons, particularly if people have an annual review that was supposed to take place maybe quite close to the start of the lockdown and the restrictions upon us. But as soon as reasonably practical, now that we're maybe up and running in a better way to have video meetings like this, that should allow for annual review to take place. So delays here hopefully can be mitigated. Likewise, the sending out written reports following the annual reviews and decisions, there's the time frames of 2 weeks from the meeting for the report and 4 weeks for the local authority to make a decision. That sometimes, in my experience, wasn't met. And again, here we've now got a relaxation of that duty to comply as soon as it's reasonably practicable. That will obviously depend on staffing arrangements and how quickly people are able to put that report together. But hopefully that's something that could be spoken about during an annual review meeting in preparation, so that we might know when that decision will be provided. If we are amending an EHCP following annual review, that timeframe is relaxed, so no longer must be finalised within 8 weeks of sending the EHCP. If a request for assessment is carried out, the normal timeframe for that was within 15 days of receiving the request. That is also relaxed to as soon as is reasonably practicable. As with the finalising of an EHCP, the requirement to consider mediation is included in this. The ordinary period for parents or young people is 2 months of decision. Equally, in terms of the mediation certificate, the ordinary position was that within 3 working days of parents or young people contacting a mediation provider and saying that they didn't want to have mediation, they were to receive a mediation certificate. That time frame is as soon as reasonably practicable. That, of course, could create some delays in parents being able, or young people being able to lodge their appeals if they don't have a mediation certificate. So making sure that the mediation provider is able to provide that promptly, even if it's not within those 3 working days, remains important. And the time frame for local authorities to comply with tribunal orders. Different tribunal appeals have different orders that flow from them, and time periods, of course, that then associate with that. Those are also altered to as soon as is reasonably practicable. So, let's say a large number of changes. But we've got to think about whether the reason for not complying is that the local authority is genuinely not able to, due to reasons of incidence or transmission of the coronavirus, or if they are trying to use this as an excuse to not comply but haven't identified why they're not able to do that by reason of the incidence or transmission. Why is it impracticable for them to comply? What actions have they taken to attempt to do so? And how long will it take them to comply? Looking at their staffing arrangements, if they can have an idea about why they're not able to comply, that means they understand perhaps where their staff are, what their backlogs are, and they have an idea about what time period will be reasonably practicable. Obviously, this is it makes it more difficult for parents and young people to get these decisions out to local authorities, but if the local authorities are going to rely on this reasoning, then they should also be able to have an understanding about when they should be able to comply as soon as reasonably practicable. We think about then how delays can be reduced, and we think about new ways of working. So the guidance includes the local authorities establishing virtual advisory panels, which will be obviously very important in terms of those decisions that are taken and then communicated out. Panels can be held maybe more flexibly now, depending on people's availability to communicate on a virtual system. So more possibilities for arranging those more quickly or more frequent panels to ensure that we can get decisions looked at. Where assessments require some more information, we need to think about, well, how do we gather that information for the assessment in a way that's consistent with reducing the transmission of the coronavirus. So we can think about gathering information by phone or virtual meetings. So, for example, in a need for an EHC needs assessment, there's a requirement for an educational psychology assessment, but can the educational psychologist consider how they can, having read the information, gather information by phone or a virtual meeting? Just because they're not physically able to attend on the child doesn't automatically mean that they can't then carry out this assessment. So consideration needs to be given to how we're a bit more flexible in terms of gathering evidence and information and getting decisions made. And local authorities can't apply blanket approaches, so each matter is an individual decision and we must therefore approach it on that basis. I won't go through everything in detail, but I've listed things that have not changed as a result. Maybe a key one for many people on the call, parents having at least 15 days to respond to the draft EHCP. That has not changed, I think primarily because the original wording was that parents were to have at least 15 days to respond. So it wasn't a set maximum time frame, and therefore if parents required additional time, they could request it. Here, likewise, it's extremely busy at this time in terms of competing duties, childcare responsibilities, employment responsibilities. So if more time is needed, then that can still be requested from the local authority. The right to appeal to the tribunal has not been removed. I mentioned before in terms of getting a mediation certificate that might create a delay, but the right of actually appealing to the tribunal still exists. The form and the content of the EHCP is exactly as it was before these amendments were brought in. Also, maybe a very important point at this stage is that the age limit for education, health and care plans has not changed. They come to an end at the end of the academic year in which a young person turns 25. That may be a point of further consideration where young people might be missing out on educational training at this difficult time, and so that might be something that needs to be reviewed in the future to address any detriment that might have been encountered at this point. So the original legislation understood that sometimes there were going to be delays for reasons, family emergencies, children being out of the area. There were or other reasons for a time delay. Within the code of practice that was set out that if there is going to be a delay, local authorities should aim to keep those delays to a minimum, and the guidance emphasises that again here. And as soon as the conditions that lead to a reason not to comply no longer apply, the local authorities to endeavour to complete that as quickly as possible. So just because a situation exists immediately, that means it's not possible to comply with the time frame. Once that situation changes, maybe it's in relation to local authority staffing or where a child is and whether a child is being shielded, the local authority can then look to move forward as quickly as possible and should be doing so. And the delay that might have been incurred before should not then have a knock-on delay in terms of anything else that happens. So if we've encountered delays during the assessment process or gathering the evidence or putting the plan together as it's gone through at this point, if at the end of the 25th of September we've still encountered delays but the normal time periods then apply, all other steps that need to be taken will be taken in accordance with the original time frame. They're not then equally delayed, and so I think that's important to bear in mind as we look at how we might come out of this. When we think about the provision that is required, we know now from the Secretary of State's notice that there's a modification to the Section 42 duty in the Children and Families Act, and so the original duty, as I've put on the slide, was for local authorities to secure the special educational provision for the child or young person. So that would be the provision recorded in Section F of the HCP, and for a similar duty on the relevant health bodies for provisions specified in Section G. Now, with the modified duty, it's a reasonable endeavours duty. So then we think, well, what does that mean in terms of complying with that duty? What are reasonable endeavours? And we have to think about that. Now, I just want to talk quickly about the reasons that the Secretary of State has considered it's appropriate and proportionate to give this notice. It was not necessarily a popular decision. I think we can easily say, but it is a decision that's been taken. But it recognises that local authorities and health bodies may not be able to meet their duties as they were able to before because of children maybe not being able to attend school or staffing arrangements not being as they were. And that obviously could be a potential difficulty in securing the provision. So that's said to be the basis for the relaxation. And it was also considered that an alternative to this is how else could provision be delivered, but it was said that this would not represent an effective alternative. So remote provision, even if it's the equivalent, would not be that specified in the HCP. That's the basis of the Secretary of State's notice. And it's considered that it's proportionate to make this notice because it allows local authorities and health bodies to adapt for their area specifically on the nature and demands of the coronavirus outbreak and the impact that that's had on their workforce and therefore their ability to meet needs, as well as individual needs as well. Some children may be attending school, some children may be able to engage in different sorts of education arranged in different ways, and some may be shielding, and so it's obviously impossible to deliver every part of the provision for those cases. So then we're looking at using reasonable alternatives, and this is with the reasonable endeavours, best endeavours duty. We must be clear, though, that the local authorities are not absolved of responsibility, neither are the CCGs, for using reasonable endeavours to secure or arrange the provision. So it's not just a complete abolishment of the duty, but rather that we look at the reasonable endeavours to secure provision. For some people, it might mean that provision can continue exactly as it was, and that there's no impact because of their individual circumstances, their own personal circumstances, and that of their school or education provider, that enables the provision to be delivered exactly as it was. I think there's going to be a limited number of those cases, but I think it's important to remember that the guidance recognises that, and that ties into the fact that we say this is not a blanket approach and it's an individual decision. So where we're not, where local authorities or health bodies are not then delivering provision, they should be keeping a record of that and confirming to parents or young people what they've decided to do and explain why the provision differs from that in sections F or G. And they must keep that under review as well, because the circumstances may change. And we need to focus on the provision that's already described, the availability of those who can deliver that provision, and then what is needed to be done so that that can be delivered differently. And the framework for reasonable endeavours is set out in the guidance, and as I've said several times, will vary according to specific local context and children and young people's needs. But in considering what is a reasonable endeavour to meet that duty, the local authority or CCG should be asking itself these 5 questions. So what is the provision that's stated in the plan originally? Where could the, and then what is a different provision that could then be delivered? Where may that be possible to be delivered? Is it at a different location? Could it be in the same place? Could it be remotely? Is there a modification? So how will we deliver that? So modification to frequency and timing. So if it's possible to maybe deliver the provision at a hub where somebody can attend at a set time because there's nobody else attending that hub, and maybe the relevant therapist can also attend at that point. Well, that's a modification that might not be reflected in the HCP, but is possible as a way to deliver it. Again, when, and so we're talking about the method may alter. So, would it be virtual? Would it be a face-to-face, or would it be on a smaller group? So different options here for how to secure provision at this point, and then by whom. So if the therapist or the teacher is not available, is there maybe an assistant, a teaching assistant or a therapy assistant who can secure the provision to enable the child or young person to access provision that looks, as in terms of the reasonable endeavours, as close to that original provision as is possible. So reasonable endeavours, not a blanket approach, and the guidance provides many examples of alternative arrangements. I've set those out on the next slide because I think it's very important to consider what those are. Recognising that remote delivery can be partially successful is important, because that means that it's not closed off. I mentioned maybe educational psychologists carrying out assessments over video. Therapy could be carried out over video if that's appropriate. It's again identified that in many cases it's not possible to deliver a provision, but that means naturally, and as I said before, that in some cases it will be possible. And so this is a relevant factor when considering the extent of the reasonable endeavours duty, as alongside the other limitations as to staffing and maybe staff rotas and other such limitations that schools or local authorities may be encountering. And we need to look at how to secure the provision as specified, or whether it can be specified, whether it can be secured in a modified form. And keeping it under review is important, because the position and action that we're taking today doesn't automatically mean that it will be the same position tomorrow. Things are changing quite quickly as we go through this period, and that could mean that what is not possible today could become possible tomorrow. And so if that's the case, then we need to be thinking about how do we adapt and to make sure we're complying with this reasonable endeavours duty. And examples of part-time timetables are examples of alternative arrangements include part-time timetables, alternative locations, adjustments to home to school transport in line with alternative placements or timetables, which I think is important because home school transport is often fixed, but if we need to consider, and it's within the guidance that local authorities need to consider adjustments to that arrangement, it's therefore in the guidance for parents and young people to rely on. Lots of other examples in here as well, so including speech and language therapists delivering sessions via video link or travelling to receive therapy at an alternative suitable premise. Includes possibly counselling or CBT to being delivered over the phone, and I think helpfully for EHCPs where people have personal budgets and taking direct payments, they could look at whether it's possible to purchase equipment or other relevant material as part of their provision under the EHCP to ensure that we've got access not necessarily only to the people, but also the equipment that is necessary to be able to engage with that provision. And we can look at as well at parents being loaned any school equipment if that's possible, which, you know, if we've got specialist adapted maybe chairs or other such equipment that's necessary for a child or young person, then is that available to be loaned? For my mind, this just the changes raise some questions with me, and I've put these on this slide. One of the interesting parts of my job is that we represent children and young people often through their parents who are finding it difficult to find the right school or a school refusing, and these children and young people tend to, for want of a better phrase, fall through the cracks. And then we can think about education otherwise and at school. And we can see with what the guidance identifies that there are many different ways of possibly securing provision. And will this in the future give us the opportunity to write that into the EHCP in a different way, knowing that there is a possible way of delivering suitable education in a more flexible manner than we've previously been trying, and attempting to get children and young people to go into a school where often that can be a barrier. Just getting into school can be a barrier for them. So adjusting how we work might actually be a benefit of this if we think about how we then use this in the future. I said in terms of the guidance that the local authorities and the government are saying that at the moment parents won't be have non-attendance proceedings brought for them. I've no idea. Nobody knows how long this coronavirus will be with us, and that makes me wonder whether schools are opened up and there's an expectation for everybody to go back, but not necessarily that everything has been resolved in terms of coronavirus and there are very vulnerable people. As a reasonable justification defence to non-attendance proceedings, which is sickness or any unavoidable cause why you can't go to school and why parents can't secure attendance at a school. And so I wonder whether this situation that we're currently in and which may persist will become a reasonable justification defence in the future once schools are opened up and once the duties start to apply as normal. Will we see any judicial review claims against local authorities or CCGs applying blanket policies? I would certainly hope that we aren't seeing blanket policies, the guidance really preventing that, but that doesn't necessarily mean that there won't be any put into place, and if any are identified, then instructing solicitors to review, seek a judicial review of those would be an appropriate step. I've not mentioned today so far about the tribunal itself, purely because we're limited in time for today, but the tribunal has expanded to now operate for hearings on a remote basis. There's been quite a long period of time with a backlog of not being able to hear cases and with cases being adjourned. So now that we've got this system, we've effectively got three possible ways of hearings taking place. So remotely, on paper based, or on an attended hearing. So I wonder if that would increase the speed at which the tribunal is able to make decisions, perhaps reduce the amount of adjournments that we're seeing of cases. Obviously, that would all be to the benefit of children and young people. I mentioned earlier as well about the age limit for EHCPs being extended. Will that be increased to offset any lost education at this point? Potentially any pupils who were being considered to have come to an end of their education at the end of this academic year, and maybe local authorities made or proposing to make cease to maintain decisions. Will any of those decisions be removed in light of the absence of the normal provision that would have been otherwise been expected, and what impact that's had on a child to meet their educational outcomes? If there's not fewer decisions originally made, will this assist in tribunal appeals? We can think maybe for children who have missed substantial periods of time, will they be decoupled, so from their current academic year? So maybe it's appropriate for some to repeat that year. I think that's obviously an individual decision and something that needs to be considered carefully. But if there's a substantial amount of education that's being missed, whether it's appropriate for effectively that child to start that year again to make sure that they get the full benefit of that year. And will we be back to normal after the 25th of September? I've no idea, but I put that question out there because what is back to normal now, really? As I say above, we've got lots of different ways that we might think about how we, although this is a terribly difficult situation for everybody, how we might find ways to improve provision in the future by seeing what works. And so do we really want to go back to normal at the end of it? Just briefly on social care, because we have limited time. In terms of children's social care, there was no change to the duties as they are as to section 17 and section 20. A disabled child is still a child in need. The duty to assess in accordance with the working together to safeguard children's statutory guidance and providing services continue. Obviously, there was the adoption and children coronavirus amendment regulations, and that was debated in Parliament today. And unfortunately, for people who are concerned about the impact that act was going to, those regulations were going to have on children in care, that was supported today in Parliament. I know there's a judicial review ongoing in relation to some aspects of that, but that would be an entirely different talk. So the fundamental principles of a child in need, whether a child needs to be assessed and what services they require, continue to exist and are not amended. In terms of adult social care, local authorities could make individual decisions in terms of Care Act easements, but they should be taking those on an individual basis and specifically in accordance with the wording that I've set out on this slide. They should only be doing so where it's proportionate in the circumstances and the local authority identifies it's no longer reasonably practical for it to comply with its Care Act duties. As it stands, there is only one local authority at the moment, as far as I understand, who are operating an easement. I think Derbyshire removed theirs earlier this week. So the Care Act duties for adults continue to apply. There are 4 stages that local authorities can go through at this time in terms of working out what easements to apply. I've set those out on the slide. There's also 4 powers that they could then choose to use. So in terms of carrying out their assessments of needs, financial assessments, preparing care and support plans, or meeting needs. Those are all parts that could be amended, but until the local authority enacts its easements, then that original provision stands. And importantly, for those people going through assessments at this stage, care packages can't be reduced just because of the coronavirus. So provision is still based on eligible needs, and we need to be thinking about what's actually required. We're not, and maybe thinking longer term as well. So I appreciate at the moment, for example, it might be difficult to secure some services, perhaps day centre services, but that doesn't mean that in terms of what an eligible adult requires, it doesn't mean they know just because at the moment it might not be possible to go there. So again, making sure that decisions are properly made by local authorities. I think that's come to an end of my slides. So if I just hand back to you, Emma, I wonder if we've got any questions you think it might be helpful to go through that have come in whilst I've been speaking.
Yeah, we've had lots of questions, Steve. So I'm just going to try and group them together as themes. So first one is, if a child with an EHCP is now a school refuser or will not cope with the changes within school, what in the long term will the local authority legally have to provide?
Okay. So I think long term, the local authority legally has to provide what is in the provision is in section F and the placement that's in section I. If a child is a school refuser or won't cope with those changes, I think what's important to consider is what might work, and is it entirely impossible for the child to go to school, and trying to then maybe hold an annual review as well to think about what amendments we need to make to the EHCP to either enable them to go to school, or if they're just not going to cope in that school at all and it's therefore unsuitable, to identify an alternative school for them to go to. So the long-term duties, once we come out of this, have not changed. But if the circumstances of the current situation have altered what a child or young person is able to cope with or manage and access, then we should be looking at amending the EHCP. And as I said during my talk, if we've found ways perhaps that have worked at the moment, that mean that the child is able to access education in a way that they weren't maybe previously able to, because they don't have to worry about going to school because they can get the provision delivered at home, or can we think about how we can get that secured in the EHCP for a longer term alternative?
Brilliant. I'm just scanning our other questions. So we have one here. Our child has gross motor problems. We've not had much NHS physio, none over lockdown. I think that's probably the case for many families, certainly families that I've spoken to that we're sort of acting for at the moment. But the question goes on to say, we see a private physio, can they send a report? Does it get taken into consideration? Can they come to reviews, or does it have to be NHS? So I think, Steve, addressing really whether families can use private reports and therapists essentially to help with the process. Certainly.
I mean, there's absolutely no reason that private therapy reports can't be taken into account. A reasonable local authority will gather evidence from lots of different sources in terms of making decisions during a needs assessment, or maybe a child has an EHCP already and they're looking at maybe adjustments and amendments that are required for that through the annual review. So a private treating therapist who has knowledge of the child can certainly provide a report, and there's again no reason why they can't be invited to the annual review meetings to contribute. It's if we were to think about, I suppose, long term, what the impact would be if a local authority refused to consider that and we ended up in a tribunal appeal, that evidence is still evidence that the tribunal would consider, because they would have that information within the bundle, they would decide what weight to give it, but there's absolutely no bar to them being able to consider that and then rely on it and maybe make either recommendations as to whether a needs assessment is required, or if an EHCP is required, or whether the content of the EHCP needs to be amended. So certainly that should be taken into consideration now, as always. And I would think if a private therapist is maybe the only person currently able to secure that provision, they will have the most up-to-date information about that child, and so absolutely appropriate that they contribute so that we've got a clear position now as to what the child's needs are, because they might be changing. And Steve, I mean, that's the position, isn't it? Is my understanding, whether we're in the current coronavirus situation or pre-COVID, really, that if families have sort of recourse to private therapists, then they can be used in that way at any time. It's not just because of the current situation that we're in. Yeah, absolutely. I think it's perhaps a common misconception, and maybe that's one that originates from within local authorities that goes to them, to parents, that they can't take account of private therapy reports. The weight to which they give a private therapist report is a different matter, but there can't be simply a refusal to consider that evidence, because it is evidence about a child's needs. It's evidence about what provision might be required. If the local authority chooses not to follow what's in that report, that's a different matter, but it doesn't mean that they can just sort of close their mind to that information.
Brilliant. We've got several questions, but I don't think we're going to have time to go through them all. So I'm just going to try and pick out another couple before our session ends. So this is just a short question, Steve, but essentially is sort of geared towards, I suppose, the current digital era that we're in. So this question is, can I ask under section 42, should the local authority be putting in online tuition, or I suppose other electronic means really for teaching and support?
I think the short answer is yes, it could. I suppose whether a local authority is best placed to do that or whether a school is best placed to do that would be a different consideration. Obviously, if we've got a child who isn't attending a school, the local authority could be thinking about developing such a program. There are lots of alternative education kind of providers, online providers coming up, and it might be that local authorities want to think about commissioning those maybe on a larger scale. So I don't think there's anything that absolutely, there's certainly nothing that prevents them from doing so. And then I think it would be a question of them deciding whether that was something that they needed to do to try to take a reasonable endeavour to secure the provision that a child or young person might require. And I say it might be difficult on a local authority scale, just because of the number of people that might be accessing that and the differentiation that might be required, and online learning not necessarily being as responsive and able to accommodate individual needs if it's sort of on a mass scale. So I think it would certainly be interesting to see whether local authorities look at investing in, say, maybe contracts with alternative education providers and online providers to increase the options and opportunities for children and young people as we move through this period, but then also when we come out of it.
Yeah, it's so it's so difficult, but also interesting to see how provision is going to adapt, I suppose, particularly in the current climate. I think we've got time just for one more question, so I'm going to ask this one that came in early on during the session. So, Steve, this question says, my son's independent boarding school for children with SPLD closed permanently due to COVID on the 1st of April. My son hasn't had any education since then, has been at home. The EHCP was reviewed in December. The new amended proposal arrived on Friday last week, I assume. That still names the old school and doesn't acknowledge that the family's son will have care needs going forward, and he turns 18 on Saturday. The family have been asking for an assessment of needs or a Care Act assessment since February. Is there any action they can take?
I mean, that's not to sound like too much of a lawyer, but that's a very specific question that I think requires actual specific legal advice. Although there's some obviously some principles in there which I think it's important to draw out. The first being in terms of when action has been taken and delays so far, that the EHCP was reviewed in December and then it took until Friday for that to arrive. I said during the talk that the amendments kicks in from the 1st of May, so that doesn't excuse any delay from the local authority before. That's a proposed, an amended draft, perhaps. EHCP names of placement wouldn't be correct. Draft EHCPs don't name placements usually, and so there's no reason for that to be there. Clearly, the local authority needs to be consulting with alternative schools or colleges for this young man to be able to go through. In terms of the assessment of needs under the Care Act, and say there's no reason that can't be carried out now. I think what's important is that the tribunal has the national trial in place, and so that gives it power to make recommendations about health and social care. So if it's ultimately not possible to resolve everything, it might be something, it might be worth considering whether an appeal to the tribunal is required in terms of placement once an appeal right is given and the EHCP finalised, even if finalised with the placement that's disputed, so that the tribunal could think about making recommendations as to whether a Care Act assessment is required. So I think there's lots that this person can and almost certainly should do, but I'm going to stop myself from talking too much for fear of sounding like I'm giving specific legal advice.
Thanks, Steve. That was like an exam style question, I suppose, that last one, but it's very evidently real life. So hopefully the person that's asked that has had sufficient information from us this evening to help with that. All right, I think we're going to have to just wrap things up now. Time has flown by. So thank you, Steve, hugely for delivering that really informative session. I'm sure all of you on the webinar will have found it useful. I know that I certainly did. Again, I just want to say thank you all for joining us and submitting the questions that you have done. I'm really sorry we couldn't answer everything during our time together, but if we haven't responded to your query, I'll pop up the email contact details at the end of these slides. So please do email us and we'll get back in touch with you very quickly to help further. So there is a slide up. Oh no, that's the wrong slide. There was a slide up. There we go. The slide in front of us at the moment is just directing you to the Irwin Mitchell Coronavirus Hub that we have. So this is a page that's updated continuously with the latest guidance and is available for you all to access. So I would encourage you to visit that if you found this evening's webinar helpful. We are also hosting future webinars as well, which again you might wish to sign up to, and these can also be viewed on the hub or on our webpage. So please do take an opportunity to look and sign up if there are any sessions which you think might be of help or benefit to you. For our families with for all of our families on today, I just want to mention that we've produced some material we've called Our Children, which I think actually is really relevant to what we've been speaking about today. So again, I'll make sure that that is sent out to you all with the follow-up material. OK, so final slide, which everyone just had a sneak peek at there. There we are. Has our contact email address on, so please do get in touch with us by email at the Irwin Mitchell events team email on screen now if you do have any further questions that we've not managed to cover today. Also any feedback and any suggestions for future webinar topics that you might find helpful or would be of interest. We've got a real wide range of teams here at the firm and would look to accommodate any suggestions for future webinars wherever we can. So that's all from me and from Steve. I just want to say again a huge thank you to Steve for sharing his time with us, and for all of you listening at home. I do hope that it's been helpful. Please continue to stay safe, everyone, and thanks again for joining us.